5 seconds to go. Start. It was pointed out that Section 10(2) explicitly distinguishes between transport vehicles and LMV, treating them as separate categories. Mukund Devgan 2017 erroneously subsumed transport vehicles under the broader category of light motor vehicles. It was also contended that the requirements for obtaining a transport vehicle license are distinct and more rigorous because the drivers of transport vehicles are entrusted with the safety of passengers, including school children and strangers who repose their trust in the driver of the transport vehicle. In his turn, Mr. Neeraj Kishan Kaul, learned senior counsel, emphasized that the classification of transport vehicles under 7,500 kg within the definition of light motor vehicles under Section 221 is a broad definition based on weight. He contended that this classification does not imply that the licensing regime under the MV Act is also determined by weight. According to the Council, licensing under the MV Act is linked to the intended use of the vehicle. Specific attention was drawn to the definition of a transport vehicle in Section 247, which refers to a public service vehicle, a goods carriage, an educational institution bus, or a private service vehicle. Mr. Cole argued that in the separate definition for each of these categories, one common factor is discernible as each provision uses words like use, used or adapted to be used, constructed or adapted for use. This shows that the licensing scheme is based on usage and not the weight of the vehicle. Mr. Tushar Mehta, learned Solicitor General, submitted that the definition under Section 221, which includes transport vehicles, is for a different regime set under Section 113 and 115 of MV Act. These sections are contained in Chapter 7, which is titled Control of Traffic and pertain to limits of weight and limitations on use and power to restrict the use of vehicles. In this context, vehicles of specific weight may be prohibited from certain roads or areas, thereby making weight a relevant factor. Under the said definition of LMV, weight has been kept as a factor for demarcation between LMV and transport vehicles only for the purposes of determining the road tax. Rule 31.2 and Rule 31.3 of the rules prescribe the syllabus for training drivers for non-transport and transport vehicles respectively. It was submitted that the said syllabuses are not the same. Also, the MV Act provides that the minimum period of training shall not be less than 21 days for non-transport vehicles as opposed to transport vehicles, for which the minimum period of training shall not be less than 30 days. In her turn, Miss Archana Pathak Dave, learned senior counsel, presented to the bench a photograph of a bus weighing 7,450 kg, just below the limit of 7,500 kg. She argued that if a school bus is operated by someone holding a light motor vehicle license, it could be very risky. It was asserted that weight should not be a determining factor for licensing, rather, it may be relevant in contexts such as taxes, permits, and other regulatory considerations. Ms. Dave pointed out that Mukund Devgan 2017 failed to acknowledge the necessity of a Form 7 endorsement for LMV license holders to drive transport vehicles. This endorsement is crucial as LMV license holders cannot legally drive transport vehicles without it. Furthermore, Section 9(6) requires competence testing specific to the type of vehicle, necessitating separate licenses for LMV and transport vehicles to maintain the MV Act's regulatory coherence. Mr. P.V. Suresh, Learned Counsel, representing the intervener, the Society Against Drunken Driving, an NGO, argued that road safety is considered a fundamental right. He argued that the decision in Mukund Devgan 2017 has led to unsafe roads by permitting untrained drivers to operate transport vehicles. It was submitted that Section 7 of the MV Act requires an individual to hold a driver's license for at least 1 year to obtain a learner's license for a transport vehicle, which is a critical safety measure. Mr. Shivam Singh, Learned Counsel, argued that motor vehicle insurance policies had ensured adequate risk coverage only when accidents were caused by vehicles for which drivers had valid licenses. However, in Mukund Devgan 2017, this court referred to the weight of the vehicle rather than vehicle usage as a relevant market for statutory purposes. Consequently, insurance coverage through judicial decisions had to be extended to cases where drivers with LMV licenses were driving vehicles outside their licensing permits. On behalf of the claimants, we have here learned senior counsel Ms. Anita Shenoy and the respective submissions of Mr. Devrat, Mr. Kostub Shukla and Mr. Anuj Bhandari, learned counsel. While supporting the interpretation in Mukund Devgan 2017, the council would contend that the vehicles under the MV Act are differentiated according to their weight. They argue that the definition of light motor vehicle in section 221 is an inclusive definition which encompasses multiple variety of vehicles including transport vehicles the weight of which does not exceed 7500 kg. The learned counsel Mr. Devrat contended that the licensing system under the MV Act categorizes motor vehicles into two primary groups, that is, light and heavy categories LMV and HMV respectively. It was argued that if a motorcycle used for hire weighing less than 200 kg falls under the class of transport vehicles, countless drivers operating on platforms like Rapido, a bike or hire service, would be required to obtain fresh licenses if Mukund Devgan 2017 is overruled. Ms. Anuj Bhandari, learned counsel arguing for the claimants, took us through the history of the inclusion of transport vehicles as a class under the MV Act. It was submitted that for the last 34 years, licenses have been granted in the country on the basis of weight of the vehicle. Even today, Form 2 specifies the grant of licenses based on weight, with exceptions being made for vehicles like road rollers, e-rickshaws, or a motorcycle. He pointed out that the original legislation identified four types of vehicles: medium goods vehicles, medium passenger vehicles, heavy goods vehicles, and heavy passenger vehicles. With the 1994 amendments to the MV Act, these categories were clubbed into a single classification of transport vehicles. Building on this, Mr. Bhandari contended that transport vehicles under the MV Act meant medium and heavy vehicles. Therefore, individuals with an LMV license were entitled to drive a light transport vehicle weighing less than 7500 kilograms, whereas additional requirements of a medical certificate and experience would apply only to those medium and heavy transport vehicles which exceed the weight limit of 7500 kgs. It was argued that the Parliament changed the nomenclature by merging the four categories into a single class of transport vehicles to simplify the licensing scheme. Mr. Kostub Shukla, learned counsel, projected that careful reading of all the definitions in section 2 would make it clear that the definitions were primarily bifurcated as follows: class of vehicle which mandatorily referred to weight LMV section 221 up to 7500 kg HMV passenger goods section 216 and section 217 exceeding 12,000 kg. Stop.